She has deposited 1 lakh. I am still.
Yes.
She has deposited 1 lakh. Now they take a bond. Bond is not honored. The student does not have any income. How they will realize the money? From where? Air.
Matlab they have relied one
Then
judgment of Jodhpur High Court.
as a sovereign, then the state must have a vicarious liability. Why not?
Matlab they have relied one
They will
judgment
not
of
accept. What you are
Jodhpur.
saying,
Malad, most of the documents have been placed by my learned friend, Malad. But may I start with the factual situation first, Malad? What, what is the situation today? Situation as on 3rd of December, Malad. If your lordship kindly takes, Malad, whether at all, Malad, uh, this discussion will ultimately become Malad academic or not, Malad. Kindly considers that part. I'm not saying Malad anything. But kindly takes page 46 once, Malad. Kindly takes the schedule, the extended schedule, which my learned friend relies on to say that he should get an opportunity to show the seat as vacant seat in the fresh round of counseling. If your lordship kindly takes page 46, your lordship will find at serial number 5. The Malad, as my learned friend submitted, when the writ petition was filed, Malad, the up to this stray round, it was over. There was no extension. But when the writ petition was pending, then this extension came, and therefore, Malad, it changed the arguments in the writ petition. Now, Malad, if your lordship takes serial number 5, online choice filling and choice locking by the verified candidates in the list, that is up to 28th of November 2024 after 4 p.m. till midnight of 29th of November 2024. Therefore, all the students who intend to participate in this extended round has already filled up their choices as on 29th of November 2024. So choice filling is over. What is to be done today after 4 p.m.? That is serial number 6, publication of allotment result of the special stray round, meaning thereby that whatever as the choice has been filled up to 29 November, this result is to be published at 4 p.m. today. Therefore, no student is today going to come and apply for JNM's seat, assuming Malad that is to be kept vacant. Now, that is the factual situation. Now, Malad, if your lordship kindly takes Malad the 23rd September 2024, Malad, that is our guidelines, Malad, which is Malad part of that Malad loose bunch. Second last page, Malad. The second paragraph, last 4 lines, which was placed by my learned friend, Malad. Second last page, 23rd September 2024. The seat surrender is not allowed from round 3 counseling any further till the counseling process is over. Now, we are concerned with a round 3 seat here. The seat surrender with payment of bond penalty is possible only after the counseling of the rounds are over for the session 24-25, meaning thereby that even after this extended round, this will apply and there cannot be any seat surrender. My learned friend is absolutely correct. I agree to him that this is pertaining to a student. Now, my submission is that even if it is applicable for a student, this 4 lines, as well as question number 16 in the information bulletin published by MCC, that is the Medical Counseling Committee, both, even if applicable for the student, there is no surrender in the eye of law. If there is no surrender in the eye of law, the college cannot come and say that my seat is vacant and declare it as vacant. Unless the student is allowed to surrender by virtue of these 4 lines.
What for the special round of counseling was done by?
Malad,
what for the special round of counseling after 3rd?
Malad, I'll tell you, Lordship, Malad, after this, Malad, your Lordship knows, Malad, these seats or increase of seats are approved from time to time. A college may have 50 seats and then thereafter it may be approved another 25 seats or 30 seats. Now, Malad, during the counseling process,
it will be increased.
Malad, during the counseling process in this case, Malad, for 3 or 4 colleges, Malad, these seats were increased. And along with that, the other stray vacancies which were there, Malad, all were put together and a decision was taken.
How that stray vacancy came?
Malad, stray vacancies where no one took admission. No one took admission. It was not allotted to anyone. left out vacancy. Matlab, there's a term used is, I'm grateful to my learned friend, left out vacancies. Those are not seats where someone was allotted but they did not join. Matlab, few categories are to be carved out here. One is a seat where no allotment is made. That is not the petitioner's case. Next is a seat where allotment is made but no one joined. And the third is that someone joined but they are not prosecuting the course. That is a completely third aspect altogether. Here we are concerned with the second part where an allotment is made but no one comes to join. In that case, my learned friend will agree that these private management quota seats, in these seats, a bond is taken saying that, and that is absolutely in line with the Rajasthan judgment, that a bond is taken to say that if you do not join, the original documents will not be returned unless this bond amount is paid. And if your lordship sees the Rajasthan judgment also, it is on that premise itself. If your lordship takes paragraph 2 and paragraph 9, what the contention of the petitioner there was that do not take a bank guarantee, take a bond. Because if you take a bank guarantee upfront from the parents for the upcoming 5 years, the person is having to pay the bank guarantee charges to the bank for 5 years. So in place of bank guarantee, take a bond. That is the first prayer in the PIL, which was moved before the Rajasthan High Court. Along with that, if your lordship takes paragraph 9 of that judgment, the entire argument is recorded where he gives the calculation that if a bank guarantee of 56 lakhs is to be given, the ultimate resultant effect is 69 lakhs. And for that, the prayer was direct the state colleges to give a bond in place of bank guarantee. And that is, my lord, exactly, my lord, what is there in the last line of this 23rd of September 2024. Now, my lord, the information bulletin has been placed, my lord. If I may place 3 more pages from that information bulletin. If your lordship first kindly takes, my lord. Now, this is the Medical Counseling Committee's information bulletin, which is applicable throughout India, my lord. Now, my lord, if your lordship kindly starts from page 8 of that bulletin, there is a flow chart. Page 8 is not relevant for us, but the continuation of the flow chart at page 9 is relevant for us. It starts at page 8, kindly takes page 9. Now, my lord, your lordship will find towards the middle of the page is the round 3 seat allotted, which is the situation here. Round 3 seat allotted. Now, kindly takes from the right hand side. Your lordship will kindly take the third column, which is report to allotted institute complete admission formalities. Under round 3 seat allotted. Report to allotted institute. Then next is if next in line, the flowchart is join allotted seat. And the third one kindly takes once joined, candidate cannot upgrade or resign. Therefore, my lord, from the third round onwards, all over India, my lord, the resigning from a seat or surrender from a seat after round 3 onwards is not permitted. It is not only a situation under the West Bengal Medical Counseling Committee. It is applicable throughout India. Now, my lord, kindly takes page 39 of that bulletin. This also, my lord, the chapter starts at page 38. Relevant part is at 39. Chapter 12, starting at page 38, kindly takes page 39. Challenge. Not under challenge. These regulations are not under challenge. But we'll kindly take page 39. The heading round 3. It is bold and underlined. Your lordship got it. Kindly takes H there under 3H. If allotted a seat in round 3, a candidate who does not report will exit with forfeiture of the security deposit and will get eliminated from the further rounds of counseling. Also, your lordship will kindly take G. G, second sentence. Once joined, he cannot upgrade or resign from this seat. Therefore, this is the bar on the student to resign from the seat at all. Therefore, my lord, the college is self-declaring that the seat is vacant. When there is no vacancy, going by the guidelines guiding the entire process throughout India, my lord. Now, my lord, kindly takes 44, the question which was placed, my lord. Question 16. After I join third round of counseling, can I leave or resign? Once you join the third round seat, you will not be allowed to vacate from allotted third round seat. Therefore, my lord, this request of the allotted candidate, which my learned friend has annexed in his stay application at page 39, where the candidate writes to the college saying that I do not want to take this seat and I want to surrender this seat. This letter, this request itself is not permissible under the guidelines, my lord. Therefore, whether they allow it or not, my lord, that is, in my humble submission, my lord, immaterial. This self-declaration of the seat being vacant. Number one. Number two, my lord, your lordship will find, my lord, an observation of the honorable single judge, my lord, at paragraph 5, which records that it does not appear that the above referred provisions of the information bulletin or clause 15 of the notification so and so, or even the notice of the WBMCC dated 23rd of September 2024 has been challenged in this writ petition. Unlike in Index Medical College, where the specific provision of the regulation was challenged. I am not placing Index Medical College, but in distinguishing Index, I'll rely on paragraph 4 of Index, where the rule, that is 12 sub-rule 8 sub-rule D, is quoted, and that was specifically under challenge in Index judgment. So, Index, because of that challenge, is distinguishable. And if your lordship also kindly takes one judgment, 22 to the 2022, volume 18, Supreme Court cases, page 63, my lord. Kindly, my lord, for the context, kindly take 3 lines of paragraph 15 once. At page 72. So, paragraph 15, my lord. The Medical Counseling Committee issued the Information Bulletin and Counseling Scheme Bulletin for admission to medical courses in 2021. Chapter 3 of the bulletin provides so and so. Therefore, my lord, this Information Bulletin of the year 2021 was under question here. Now, my lord, kindly take paragraph 26. Last page, my lord. Since the appellants have not challenged the provisions of the Information Bulletin, which stipulate that the vacant NRI seats shall be converted to unreserved seats during the mop-up round, we cannot decide on the legality of such conversion of seats. Well, this is, my lord, the paragraph 26, my lord. Last page, my lord.
Yes.
Therefore, my lord, since the Information Bulletin was not under challenge in that matter, my lord, the Honorable Supreme Court, my lord, declined to entertain any challenge to the contents of the Information Bulletin, my lord. My lord, this is absolutely, my lord, akin to the observations of the Honorable Single Judge in paragraph 5, though this judgment was not placed before the Honorable Single Judge in this matter. Therefore, my lord, going by the schedule today, my lord, assuming this seat is at all declared to be vacant, my lord, it will still remain unoccupied because there is no choice filling and no stray round, my lord. This, your lordship knows, my lord, in the other matters also, my lord, we have placed, my lord. These timelines, my lord, all my lord, are being fixed by the Honorable Supreme Court. Therefore, my lord, we cannot extend the time, my lord, beyond what is already fixed. Therefore, my lord, first of all, my lord, there cannot be any surrender. And, my lord, the Honorable Single Judge rightly considered that there is no surrender in the eye of law at all.
That's all.
Ramakrishna, তুমি deal করে দিন।
Who is he?
But he is for the NMC, National Medical Council.
But I am also adopting the submission of the West Bengal Medical Counseling Committee. Only the Ramakrishna Medical College, my lord, the judgment placed by my learned senior, my lord, paragraph 25, my lord, where the, my lord, Honorable Supreme Court also, my lord, praised for, my lord, security deposit prior to blocking a seat by the Honorable High Court. My lord, may I read for your lordships, my lord? If the provisional admissions seats are not given casually, the said principle should also apply for direction to keep seat vacant only if there is a cast iron case for the petitioner and the petitioner is bound to succeed in the case where the error of the respondent authorities is so gross as to neglect any other collision. Interim order keeping the seat vacant could be made, though the court have power to make order directing the seat to be kept vacant. In such cases, with great caution, circumstances should be shown to the existing power. In appropriate case, even where the said exceptional creation as set out above meet, the court will be justified directing the petitioner to provide security. So, my lord, the Supreme Court is also, my lord, of the view.
What are you talking about, sir? This is
My
not
lord,
a
when
case.
court
Please.
is court,
He has a term. This is not a case. The case is very simple. They say that allotment was done, the student has resigned or backed out.
yes,
Now, what to do? According to him, the seat fell vacant.
yes,
And therefore, since the entire admission process has not completed, so somebody else from a merit should also be recommended so that the seat goes filled up.
occupied, my lord,
Filled up.
filled up, my
So this is what their condition is. All these cases are at the behest of the student. That if the court wanted to keep one seat vacant because the case has been made out, then some security is to be sought.
yes, my lord.
That is a different issue. Here the question is whether the seat got vacant or does not, because the fact remains that this seat cannot be filled up by them.
Unless and
That's the bottom
on,
line of this entire story. Nor they are expected to receive any fees from the student because who has opted out and has gone out. He will not attend class. What best they can do, they can forfeit that particular money which she or he has deposited. That's the only thing. They can't charge the future fees. Not joint. Their contention is that when they are entitled to this is when the seat got surrendered. Their case is it should be surrendered. Mere vacating of the seat or vacancy is not automatic unless it is surrendered. And they say that after third round of counseling, nothing, it cannot be deemed to be surrendered. So if it is not surrendered, then it cannot be treated as a vacant seat. This is what their condition.
yes, my lord.
So they say that, look, these are the law on the subject, and therefore, if he has not joined, they have no grievance. They cannot treat it as a vacancy to bring within that stray. What is that stray round of
Special stray
counseling
round
or
of
something,
vacancy,
whatever?
counseling.
They say we can't bring it. This has a different connotations. They have also not challenged the decision of the trial judge, where the liberty is given to approach I think the
Fixation committee.
fixation committee. They have not challenged. So they cannot say that they cannot go there, nor they can say that I will not constitute the fee fixation committee because they have not challenged the order before us. So they cannot now resile from there. So this is what is a sum and substance. You are talking about security. When the injunction is granted, just to keep a balance.
My lord, security with respect to, my lord, if after all, my lord, the seat is, my lord, not filled up, my lord, and court is against the petitioner, then, my lord, the college authority will not suffer loss. For that purpose, Supreme Court holds that, my lord, the
From
High
whom?
Court should.
No, from whom? Let us see.
Yes.
You are saying that the college should not suffer. But the bottom line of the story is that they have suffered.
For their own fault, my lord.
Not own fault. What are you
Because of this fact, my lord, they have to take the bank grant bond.
I am talking about a
They
bond.
have failed to obtain the bond from the concerned student, my lord.
What kind of a bond?
My
What
lord,
kind of a
unless
bond?
he or she completed, my lord, he has to deposit the.
What? She has deposited 1 lakh. I am still.
Yes.
She has deposited 1 lakh. Now they take a bond. Bond is not honored. The student does not have any income. How they will realize the money? From where? Air.
My lord, they have, my lord,
Then,
denied one
then
judgment of Jodhpur High Court.
as a sovereign, then the state must have a vicarious liability. Why not?
My lord, they have relied one
They will
judgment
not
of
accept. What you are saying,